Good afternoon, everybody. Welcome to the second ordinary meeting of the Statistical and Social Inquiry Society of Ireland. This is our 174th session, and I'm Danny McCoy. I'm the president of the society. This evening, we've got a symposium format with 3 speakers under the topic of jurisprudence and its impact upon public policy. I'll introduce the speakers just very briefly now and then call on them in order after the honorary Secretary has read the minutes of the last meeting, but we're very grateful to be joined by the Attorney General, Paul Gallagher, this evening. Paul, very welcome. Margaret Gray, Senior Counsel and QC, also joining us. Margaret, thank you very much. And Senator Michael McDowell, Senior Counsel, former AG and Minister for Justice. So we've got a really great lineup for the topic, and thank you on behalf of the Society for joining us, and thanks for people joining in tonight. As ever, the Honorary Secretary will keep good order in terms of how we'll engage in terms of the questions, and ultimately to bring this to the journal for a record of what our society was up to in the year 2020. So Ronan, over to you, maybe to just do the minutes and then we'll start the symposium.
Thank you very much, Danny. So what I'm going to do is just read the minutes of the last ordinary meeting and then we can get started. So the first ordinary meeting of the 174th session of the Statistical and Social Inquiry Society of Ireland was held at 4:30 on Thursday, October 22nd, online due to the COVID-19 pandemic and associated restrictions on physical meetings. The President, Danny McCoy, was in the chair, and Tim Callum and Karina Doherty presented a paper entitled Top Incomes in Ireland, Reconciling Evidence from Tax Records and Household Survey Data. Aideen Darce and Robert Sweeney led the subsequent discussion, with further contributions from Jean Atchison, Brendan Ryan, Brendan O'Dowd, Barra Rowntree, Chris Sibley and Patrick Onan. Following the discussion and responses from the authors, the President thanked those who contributed and brought the meeting to a close.
Thanks, Ronan. So, as I said, under the title of jurisprudence, and possibly when the society was set up way back in the 1840s rather, I think jurisprudence may have had a different meaning to its current interpretation, but we won't let that get in the way of a renewal of jurisprudence, which we notice seemed to have been last discussed somewhere around the 1870s. There may have been a foray in 1955 in one breakup, but we genuinely would like to reconcile in this social inquiry. It's not overly dominated by statistical, this society, but the social inquiry certainly needs that breadth that the legal profession can bring. So Paul Gallagher, would you start up? Paul's our Attorney General, second time around in the role, and Paul brings a wealth of experience to this, and thank you for honouring us tonight by addressing the society.
Thank you very much, Danny. I'm honoured to be invited to address the society. I want to talk in broad terms tonight, and with particular focus on the role that statistics is capable of playing in the legal world, but more broadly than that, the role that statistics, play in informing us in making decisions. We live in a universe where ignorance prevails. We know many things, but there is much we do not know. In this essentially uncertain world, it is foolish to ask for absolute certainty. That doesn't mean that we're completely in the dark between certainty and complete uncertainty. There is an immediate space, an intermediate space in which our lives and our thoughts unfold. And perhaps it's that intermediate space that I want to look at the moment in terms of information and knowledge generally, and then with specific reference to the law. If we lack absolute certainty, you might ask, what is the value of knowledge? Well, I think recent years have reinforced the understanding and belief of the importance of knowledge and the importance of that decision makers should attach to knowledge and proper information on which to base their decisions, whether they are policymakers or lawyers or judges. This rejection of evidence, of experts that we have seen in the last number of years is not new. When Galileo was accused of heresy by the church in the Middle Ages, he asked that the church cardinals would look through his telescope to see what he could see, and they refused to look through the telescope. They said what he was seeing was dirt at the other end of the lens, or the moons which he proclaimed to exist were within the telescope. This is not just a modern day phenomenon, but it has, as I say, in recent years, acquired a vibrancy and an importance that should alarm us all. During the Brexit referendum campaign, we all know that one of the great slogans was that this would involve, if the UK left Europe, a contribution of 350 million a week to the National Health Service, because that was the amount that the UK was paying to the EU. The UK Statistics Authority said this figure was incorrect. It was a gross figure, and it did not take account of the benefits which the UK received from the EU. Michael Gove's response to that was that in the UK, people are fed up with experts. And this idea that you reject expert knowledge, whether of a statistical type or of another type, is something that has taken hold and has cost us dear, it seems to me, in the last number of years in terms of maintaining institutions within countries, democratic institutions, and more broadly at an international level. Public policy should be informed by statistics, and public policy can take years to develop because the information which underlies and should inform it can often take a very long time to accumulate. We are perhaps used now of using public policy in the formulation of, of using statistics in the formulation of public policy. And more recently, within governments and recent governments, there's a much greater consciousness of the importance of informing legislative change, informing policy decisions with statistics. And in that regard, the Central Statistics Office plays, as you know, a vital role. The absence of accurate scientific information, which doesn't come just in the form of statistics, but in respect of which statistic plays an important role, leaves us impoverished in what we can do and in what we can achieve. In the COVID-19 crisis, we have had the difficulty that the statistics weren't there at the beginning of the crisis to inform us how we could address the issues that arose. The lack of knowledge was based partly on the absence of statistical data, epidemiological data, that could help us make informed decisions. And we have discovered the importance in developing those statistics and making informed decisions as we have acquired them through the period of the crisis. Obviously, there's still an absence of the type of solid statistical information that would be ideal in making decisions. But we've had to do the best we can with the absence of an important ingredient in informed decision-making. In turn, if you look at the broader scientific response, it has been nothing short of remarkable, because from a standing start in February, we're now in a position where we have developed a range of vaccines against a virus. And that is an amazing achievement. The development of the vaccines, of course, involved trials which involve statistics, and ultimately the approval of those vaccines involves statistical exercises and judgments that are crucial to making those available to the public. The motto of the Royal Society, as you know, is that nullius in verba. We should not take any person's word for it. What we need is evidence. We need to look at what the science says, recognizing that it has limitations and that scientific propositions today are only as good as their ultimate ability to withstand scrutiny and to withstand challenge. And it's through that scrutiny and challenge that we develop the scientific knowledge that has now created a world where at one level we still have great uncertainty, but at another level we have a surplus of information that is very difficult to handle and very difficult to digest and use in a structured way in order to make, as I say, decisions to guide our lives and to ensure that we are getting the best from the universe of knowledge that is available to us. One of the things that harms decision-making both at a policy level and at a legal level, is people relying on their gut instincts. Many people boast that they have an instinctive reaction, an instinctive knowledge that helps them solve problems. And I think we all know that is a very dangerous methodology to use to address problems, both at a scientific level, at a policy level, and very much at a judicial level, at a legal level. We must examine the basis for any instinct we have and ensure that the ultimate decision is not overborne by the instinct. Daniel Kahneman, the great Nobel Prize winner, economic prize winner, described how many people are attached to gut instincts in decisions they make and use those gut instincts to evaluate information and reinforce beliefs that they have already had. Donald Trump's former right-hand man, Stephen Bannon, told Michael Lewis that the Democrats don't matter. He said the real opposition is the media, and the way to deal with them is to flood them with nonsense. And people who have gut instincts that align with that nonsense will actually be reinforced in their beliefs and will become convinced that certain things are so. So it's that care that we need to have, that realization that gut instincts can be influenced by nonsense that is put through the myriad of media and social media outlets that now exist. Stephen Jay Gould, the great paleontologist, was told when I think he was about 40 that he had 8 months to live from a rare cancer. And he describes how his immediate reaction was one of horror, of despair. And then he reflected and he realized that in fact what the doctor had told him was that the median life expectancy for somebody with cancer of his age was 8 years. But when he drilled down through the figures, he realized that obviously this being a median, it was not the upper limit, and there were many factors that he benefited from. He was highly educated, he could research, he could identify the best doctors, he had lived in a good environment, and he could afford good medical treatment. Gould's doctor had advised him not to look at the literature, that would upset him. But as a scientist, his first reaction was to look at the literature, and he lived a long life, and he was not one of those who died within that median period of 8 years. Similarly, people's reaction to what they hear on the news and the social media is informed by gut instincts in many cases, and in large part informed by a complete lack of knowledge of statistics. Perhaps more appropriately, one should say misinformed by that. In Italy, a few years ago, there was a program on television which showed how cancer patients were reportedly recovering after being treated with alternative medicine by a doctor called Di Bella. And it was said, what better proof is there of the efficacy of natural treatments to those recovering from, or to those suffering from serious tumors? What they didn't, of course, appreciate was that by the law of averages, statistically, you will get recoveries that are unrelated to any positive effect from the treatment that has been given. And to discover whether natural remedies actually are effective in terms of treatment, you need to work out how many times these remedies have failed. You need to compare the results with those of untreated patients. You need to study the results of those who are treated by traditional medicines. But it's this presentation of knowledge to people, and that includes most of us, who don't understand the importance of scientific analysis, and more particularly of statistics, that leads people to make decisions both in their own lives and to respond to decisions that are made at the macro or policy level in a way that is misinformed, in a way that is ultimately damaging to the coherence and understanding that is necessary to have a properly functioning society achieve its best potential. Most of you, I'm sure, and probably all of you, are familiar with the book of How to Lie with Statistics, published in 1984 by Darrell Huff. And one of the examples that he gave in that book was a survey in the 1950s of the 1924 class of Yale graduates. And the survey seemed to indicate that they had an average income close to $500,000 in today's terms. And this was plausible enough to believe. This was Yale, lots of bright people. But if you drill down through the figures, you'd ask, is that really the average? And of course, the answer was no. And Huff explains in his book that this improbable, though pleasing figure was based on self-reported data, which firstly meant that certain people exaggerated their income to demonstrate their success. It was also a survey of only those people who were prepared to respond, and also a survey that related to only those people that Yale at that stage kept a record of. And the belief, not unfair, was that Yale kept a record of those graduates who did well, but was less concerned with those who did not do well. So you can lie with statistics. And of course, you can lie with any information. And the whole concept of fake news that now pervades is a demonstration of how misinformation can take hold and leave us in the dilemma that despite information apparently being more readily accessible and available than it ever has been in the history of mankind, our tools for coping with that information and for assessing it are actually very limited. So we would avoid a great deal of foolishness, and society would gain great advantages if people understood even the basics of statistics. And I'm afraid most of us don't. And this idea that statistics are for a special cadre of people, or that you require some great knowledge or learning to understand statistics, in my view, is a significant drawback. I think statistics need to be presented as just another component of knowledge. Few of us will gain any great skill in statistics, but many of us can gain a knowledge of the basic concepts of statistics that will enable us to filter and assess information. Because assessing and filtering information is something that statisticians do, something that scientists do, and it's something that lawyers do or should do, and I suspect don't do sufficiently or often enough. I want to then just look at these ideas in the context of the EU and where we are in terms of withdrawal from the EU. That has some legal dimensions that I'll come to in a moment. In the UK, the Office for Budget Responsibility has said that a no-deal Brexit will add a further 2% drop on top of the economic impact of the virus next year. That would result in more than 300,000 job losses, 0.9%, on top of nearly 1 million more people who are expected to be unemployed next year because of the virus. This, of course, raises the problem as to what is meant in truth by getting Brexit done, this great mantra. Mr. Johnson says the UK would prosper mightily with no deal, which he calls trading under Australian terms. But if we probe the statistics, what he really means is Australian terms is trading on the basis of the WTO. Australia sends a mere 3% of its exports to the EU in 2019. So that doesn't harm Australia that much, but the UK exports 46% of its exports to the EU. So if you consider the statistics, the mantra that we will prosper mightily looks a little bit more threadbare and doubtful. The market in which Australia is engaged is the Chinese market, where 38% of its exports go. That in turn is problematic because it is subject to the whims of the superpower. And as you know, in the last few weeks, China has exerted its power by slapping tariffs on various Australian goods on barley, carrying out an investigation into what it's called a wine lake that's been dumped by Australia in China because of China's perceived closeness and support of the US and Western governments. So the US government's own estimate of a no-deal trade, which it doesn't talk about that much, but is that it would affect domestic product by 8 percentage points over 14 years relative to staying in the EU. And that might amount to having cumulative growth in GDP per head over that period. The free trade agreement it seeks would cost 5 percentage points. One of the big issues is fishing. Fishing generates 0.04% of UK gross value added. The level playing field that they object to must also be put in context with reference to the statistics. In fact, the UK is one of the lowest spenders in the EU in state aid terms, Germany being one of the biggest. So actually objecting to a level playing field represents a relatively small trade restraint in economic terms, though it's considered a very considerable restraint in sovereignty terms. Mr. Johnson speaks about the UK should be treated like Canada, but the EU's imports of goods from the UK are 10 times those of Canada. So what we get are mantras that most of us are unable to assess what is behind them, what do they mean, and what is their relevance. It is statistics that help us pierce that veil of ignorance and inform us. If you then look at the withdrawal agreement in that context, as you know, Article 16 of the withdrawal agreement provides that if the protocol, the Northern Ireland Protocol, leads to serious economic, societal or environmental difficulties that are liable to persist or to a diversion of trade, the Union or the United Kingdom may unilaterally take appropriate safeguard measures. But the safeguard measures it may take are set out in the procedures in the withdrawal agreement, the procedures in Annex 7, which involved a balanced approach and a proportionate approach based on evidence and based on statistics. So when the UK introduced its Brexit bill that provided a unilateral entitlement of ministers to deviate from the agreement, that was said to protect UK's interests, but UK's interests were protected by the international agreement to which they were bound, and they were not entitled to introduce a unilateral method to deviate from that agreement or to break that agreement. And of course, the reason you have these provisions in an agreement and that you have an evidence-based assessment of whether there's an undue or disproportionate burden is that that is ultimately going to be based on an evidence-based analysis, which is going to involve, in this context in particular, statistics and statistical evidence. I then want to look perhaps more closely about how statistics are relevant in a court context. But it's more than that, because the rule of law, it plays an essential role in society. And the rule of law is ultimately only as good as the quality of the laws. And in a common law jurisdiction, the quality of the laws is informed by the decision-making of judges. And the decision-making of judges must be based not on gut instincts, but on proper analysis. Proper analysis in many cases involves a consideration of statistical evidence to establish how particular cases are to be determined, and also more broadly to establish principles that inform the assessment of validity of laws on occasions. Statistical evidence is, of course, something that may be influenced, is objective, but it may be influenced by subjective biases, and that's something we need to understand. There's a famous study by Babcock and Lowenstein, which ran an experiment with participants who were given evidence in a real court case about a motorbike accident. And one participant was given the plaintiff's brief to get as much damages as possible, and the other participant was given the defendant's brief to reduce the damages and say there was no liability. They were then presented with the actual facts of the case, and they were asked how or what would be the likely outcome. And it transpired, instead of assessing that on an objective basis, their assessment was influenced by the roles they had previously played. And that is something that we need to guard against in assessing the quality of evidence more generally, and in assessing statistical evidence that may be relevant in cases. I just want to finish briefly with just an identification of a number of cases where evidence has been assessed, statistical evidence, and has played an important role. The first is an Irish case, DPP in Connolly, where a Dr. Casey from the Forensic Science Laboratory gave evidence with regard to the probability that 5 packets which contained amphetamine, that there was a probability that at least 7 out of 10 packets did contain amphetamine, though she had only examined 5 of those. And the court accepted, having regard to her experience, that she could properly arrive at that analysis. Where she gave evidence, however, that the purity of the packages that she assessed, they were between 10 and 40%, and that percentage would apply to those packages she had not assessed. The court rejected that because they weren't satisfied that she had a proper statistical or quantitative basis for that assessment. There is then what's known as the prosecutor's fallacy, and that has been demonstrated in a case of Orr versus Clark, where a pathology expert appearing for the prosecution testified that the probability of sudden infant death syndrome in one family matching the Clark's profile was 1 in 73 million. And the implication was the event was so improbable that it was at the very least suspicious. But in fact, the figure of 1 in 73 million is the probability that 2 deaths in one family will occur among infants, where none of them is killed unnaturally. So once the 2 deaths occurred, the 1 in 73 million figure told us nothing about the statistical probability that the deaths were in fact unnatural. That's called the prosecutor's fallacy. And there is also the ecological fallacy, which occurs where an inference about a specific individual and group in an ecological study based on the property of that group is then transferred to an assessment of an individual case. Those are matters that you will all be familiar with. And you will be familiar with the increasing use of statistical evidence to determine issues as to whether there's discrimination, to determine causation, to determine whether survey evidence is admissible, the survey evidence itself containing statistical evidence. And finally, in the context of the laws, particularly in specialist areas in regulation, competition law, financial regulation, regulation in the area of telecommunications, all of those require informed statistical information. And the application of those regulations in turn are informed by properly based statistical evidence, properly assessed. So I leave you with just a strong view that I hold, that the importance of statistical evidence is fundamental to an informed assessment of issues and challenges that face us in society in general and in the legal sphere. And it is so important that people know that and understand the basics of statistics so that we can get the best from the science that you offer and that your society espouses, and that we can achieve not just a symphony between jurisprudence and statistics at a general level, but a symphony between knowledge, the assessment of knowledge, information and decision-making, whether it be in the scientific, the jurisprudence, or the broader economics or societal spheres. Thank you very much indeed.
Thank you very much, Paul. And I do realize, I'm not sure it's a legal term or a statistical term, but there's stuff going on that you need to get away now. But really do thank you for joining us. We may use the privilege of questions that come in later on to direct them to you. And if you feel that you'd like to put them on the record for the Society's journal, we'll make that facility. But again, thank you for joining us this evening.
Not at all. Thank you. Thanks, everybody.
Margaret, I'm going to ask you, Margaret Gray is going to join us. Margaret, Senior Counsel, Queen's Counsel, and along the way at the European Court of Justice as well with the great Fidelma Macken, and been through Oxford and Bruges as well. But you've got a particular angle on EU, but I think dispute resolution as well is one of those issues. So Margaret, over to you.
Danny, thank you very much indeed. And thank you to you and to the Society for the invitation. And I was delighted to hear that I think perhaps one way of putting it, as you said, that it was thought a good idea that jurists or lawyers and economists, sociologists, statisticians should all be friends. So thank you very much for the very warm welcome into the fold. I am taking your invitation, Danny, to treat jurisprudence in its broadest of forms, in broad terms. Happily, for me, because I do remember studying the subject, in fact, my degree was jurisprudence, and it reminded me of all the dusty, very philosophical books that I found it more difficult to get to grips with at the beginning of my degree. But in its very broad form, what I'd like to look at in the context of a specific topic of looking at the role of, I suppose, Ireland's common law in society, and then a very specific context of the jurisdiction of the Irish courts, agreements for that jurisdiction to be conferred in Irish courts as regulated in particular by EU law, but then mixed up in the context of the withdrawal agreement and Brexit, and how that might influence in turn public policy and also Irish law itself. So what I'd like to look at Irish law within the Irish legal system, within the context of the EU, and then try to narrow that to look at some of the interesting issues that I think arise whenever we consider how we might bring a focus to promote Irish courts and Irish law, so Irish jurisprudence in its broadest sense, as a way of determining disputes, and that's particularly key on the EU, in the EU sphere, also on the international plane, and particularly when, as Paul said, we do stand on the cusp of a pretty exceptional time, not least for the reasons that Paul spoke about in depth as regards what we've all encountered during the last year in relation to COVID-19, but also in relation to the EU withdrawal agreement and the Northern Ireland Protocol, and the challenges that are going to be thrown up by that for Irish courts, Irish law and EU law. So that's the sort of broadening out of my thesis, if you like, and then the narrowing it down to look at how some of these issues might find their way into Irish courts, and why we would want them to do so. And so I propose to look, I suppose, under maybe 4 sort of broad headings during my presentation. The first is just a brief introduction to what we might understand by our common law, and how that has been affected, maybe affected perhaps more than we might imagine, by our continued membership of the EU, particularly in circumstances where the UK, the other very significant common law member state, is no longer making a significant contribution to the development both of policy and how that finds its way into legislation and legal concepts within EU legislation, and equally in relation to driving jurisprudence both within the member state courts and also in the Court of Justice. And then secondly, I'd like to look a little bit about the role that law and the courts might play in that development. Thirdly, then, why we want to have disputes, and why parties, particularly parties who aren't already in Ireland, might want to have their disputes settled here, and how that can come about. And then fourthly, perhaps a bit of crystal ball gazing about what might happen next, and perhaps whenever the minutes of the of this meeting are being read in some hundreds of years, if the society hopefully will continue to go from strength to strength and continue, that whenever people look back, they'll see that in 2020 the society was considering the issues of moment of the day, just as I imagine in 1847 when you were thinking about what was about to happen in Europe in 1848 and what was happening obviously very, very close to home, that these events are very much events to be debated and recorded. So that's where I'm planning to center my my musings for the next 20 minutes. So firstly, back to the idea of what is the common law, and how does that fit into a broader theme of jurisprudence and its impact on public policy. Well, and I think perhaps as a complement to what Paul was speaking about, also in relation to the importance of evidence-based decision making, of facts and precision, that is all absolutely what the best jurisprudence is based on and is developed from. But there's also, I think, another element, which is that obviously the law is a reflection of our lives, and our lives are far from perfect. And there's a gentleman who I'm just going to introduce you all to, for those who don't know him. This is Mr. Oliver Wendell Holmes, and he famously said, "The life of the law has not been logic, it's been experience." And that's something which we see, in fact, reflected and phrased and paraphrased in a lot of our superior court case law, both and also in extrajudicial musings of our judiciary. And what Mr. Holmes said was that, and I'll just read out the rest of the quotation. It's a quotation that also has been woven into a very fine article by our former Chief Justice Keane, in an article in the Judicial Studies Institute journal, where he traces the development of law and the common law through a number of seminal cases, which were reacting in many respects to societal impacts and events of the time, including actually the membership of the EU. But what Mr. Holmes said was that the life of the law has not been logic, it's been experience. The felt necessities of the time, the prevalent moral and political theories, institutions of public policy, and men have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become. And in some ways, that's very, very true reflection of actually the common law, it being considered to be something that's less sort of books of stale rules and rhetoric, and more something which embodies the life and breadth of social norms and the organization of public and private lives, and a commonality of purposes then between judiciary and the nation that are determining the law's path as it develops. And in some respects, this is one way of thinking about the distinctions between, on the one hand, the common law, on the other hand, what we talk about as civil law systems. And that's something which then can be explored in more detail through the lens of European Union law, where you see those systems collide or collaborate or meld or cross-fertilize, whatever way you want to look at it. And just, I suppose, in a nutshell, and there have been a number of ways of summarising what the common law might stand for as distinct from the civil law. And Paul has already introduced those, the main traits when he was speaking earlier. But just to recall, the common law is based on judgments and precedent, a very strong tradition of looking, as Wendell Holmes says, at what has been, so that we can work out what it might tend to become. A flexibility associated with the common law and its development, and that's something which in turn has lent itself to business and commerce liking the common law as a way of organising their arrangements and agreements, as compared to the civil law, which is code and rule-based, perhaps. And perhaps that's why you might in some respects say that the experience v logic division lends itself to that distinction. And I believe that on the departure of the United Kingdom from the European Union, and that major public policy impact will have another felt impact on Ireland's role as a common law member state within the EU, because even just looking at a couple of examples of what's happened so far as a result of Ireland's membership of the EU, and the impact of policy and legislation in certain areas. If we take even the example of commercial agreements and contracts, there was a marked change as a result of a certain number of ways of trying to regulate contractual agreements, and particularly for consumers as a result of EU legislation. The Unfair Contract Terms Directive was the main legislative provision, which was very code-based provisions and legislation, which was something which was not familiar at all to Irish lawyers or to UK lawyers, who would not have approached the interpretation of contracts in that way. And that's now something which has to be addressed, and is overlooked at the peril of lawyers advising clients. And it's also something which has changed very greatly the way regulation and interpretation of contracts is now approached. Another example, and one which I'll come on to in a little bit more detail then, which I'd like to explore, is the idea of the jurisdiction of courts and the arbitration of disputes. And again, the distinction between the civil law approach, which is very much rules and code and very logical way of approaching determining where a dispute ought to be heard, on the one hand, as compared to the common law approach, the Irish law approach, which was really, it should be the most convenient forum and the court which is most closely associated with whatever the subject matter of the dispute between the parties is, bearing in mind also that there is a presumption or premium on a defendant to a dispute, with rights of defence being able to be sued in the courts of his domicile or his seat of incorporation in the case of a company or other legal person. So there are very interesting examples and very practical examples of how public policies which have found their way into legislative provisions in different member states, as against precedent and other ways of protecting fundamental principles and norms in common law jurisdictions like our jurisdiction, then met within the EU crucible and created these codes and rules and systems that then we now have to apply and use in Irish law and in Irish courts. So that's the broad introduction to where the common law, civil law, and the I suppose the dispute mechanism process then might fit in that analysis. So the second point is then, well, what role has the law and the courts to play whenever we're looking at these issues, particularly as regards where there might be these points of conflict or melding of the common and civil law systems, as has happened within the EU, and where disputes have arisen. What role can the courts play, and in particular, what role might we see for Irish courts playing, and what are the advantages of the Irish courts being involved here? And I suppose in very broad terms, and I will just speak in very broad terms at the moment, but the most traditional aspect of the role of the law is the dispute settlement function, the court. And whenever the forum of the court has been encroached upon, then there are broader issues of public policy, which then play back into that in circumstances where, and we're not the very sort of apex of these issues that I'm putting out for consideration, which is, does the court, or does an Irish court, does it have any jurisdiction to consider these issues, to hear the dispute, and to make a judgment, and then to contribute, as Paul says, absolutely fundamental to the development of a strong legal system, reasoned judgments, and a body of jurisprudence which is based on sophisticated reasoning and respected, independent, informed and expert judiciary. So how do you actually get the cases in to allow all of that to build up? Well, obviously there are disputes happening before the Irish courts every day, but there's a body of other disputes that it would be of benefit for our legal system for a number of reasons, societal reasons, economic reasons, and then the broader reason of the development of Ireland's status and profile within the European Union in the first instance, particularly on the departure of the UK, for these disputes and for Irish law to be at the forefront, and for Irish courts to be able to seize these disputes. And I don't say that purely out of self-interested motives of being a lawyer. We obviously, lawyers need clients, and they need cases to advise on, but also there is a broader issue, not just as I said, economic reasons, but it's self-perpetuating as regards the impact and the input and the influence, I believe, that Ireland can have, and the role that it can play, and particularly thinking about the role that it may play within the EU. So what is required in order to do that? Well, in the last couple of years, there has been a significant increase in this profile that the courts have had, that the legal profession, largely through the Law Society, also the Bar Council, has been promoting the use of Irish law, and Irish courts as forum and as a seat of arbitration also, particularly as regards the potential, and I think we might say in certain degrees, a likely decline of London as a choice of a forum for the settlement of international disputes. And the court service and the Department of Justice has devoted resources to increase what is available for the courts, And the Chief Justice has also been very vocal in supporting the efforts and in promoting Ireland as a forum for dispute settlement. So assuming that that's there, assuming that there is still a desire, as there is, for the common law to be used, and I spoke about particularly commercial parties, and all the US obviously is being also a common law system, likes common law jurisdictions for its disputes to be settled in as well, where that is necessary, US clients that is. So assuming that those things are in place and there is a desire, how can the disputes come? How can a court be certain whenever it has a case before it that it has jurisdiction to determine the dispute that is there? And I've spoken about the idea or the necessity at EU level to put in place a certain code which governs the jurisdictions between different member states. And that's something which has developed from a number of conventions, the Brussels Convention being the significant one back in the 1960s, and that's been developed. Now it's a regulation, Brussels regulation, which sets out in a very logical fashion the rules that apply in order to determine whether or not a court within the EU has jurisdiction to hear a dispute or not. So there are a number of reasons how a court will know and how disputes might be capable of coming to be heard in Irish courts. The first is, well, whether is there a company or here that has or a party that has a seat in Ireland and wants its dispute heard here. Obviously, the more investment and the more companies there are already here, then the more likely that is to happen. But equally, whereas the defendant, because if the defendant is not based in Ireland, then we have to look to see, is there an agreement in relation to jurisdiction of Irish courts? And this is a very key issue because, and this is one way that public policy and an awareness of the possibility of agreements as to jurisdiction and choice of court can assist with feeding back into this increased development of Ireland as a dispute resolution centre. And the idea of there being an agreement as to jurisdiction is something which is included in the Brussels regulation, in the code itself. It is heralded in the code, and it has been interpreted both by the unsurprisingly by the Irish courts as something which has to be respected in accordance with the fundamental principle of a freedom of contract or freedom to agree. So if you're a court that's interpreting an agreement between parties, you are going to look to see what the parties have agreed, if they have agreed that the Irish courts should hear a dispute, or if a dispute is raised in an Italian court, for example, and there's a jurisdiction clause which designates the Irish courts as a dispute, the Italian judge should be very slow, provided that the requirements in the Brussels regulation code have been met. For the Italian judge to be very slow to take jurisdiction of a case. So is there a jurisdiction clause? And this is something which there already have been moves to try to increase the prospects of disputes being heard in Ireland, at least in relation to arbitrations. An example is that there was a very concerted move in the arbitration forum in relation to international swaps and derivative agreements, which formerly had favoured English law and another English seats as places for the resolution of disputes arising in relation to those agreements. And now there has been a specific move to address Ireland and provide agreements that Ireland is to be a seat for the arbitration of disputes arising in relation to those agreements. So there are very simple remedial steps that can be taken, or preemptive steps, in order to facilitate this. And these are public policy issues that can be debated outside of legal circles, but in relation to the best way for businesses in this instance to have their disputes arbitrated or determined in a way that helps to develop, inform, and support the development of the Irish legal system and Irish law when it's looking at these issues. Interestingly, there is a well-known Irish airline which also has, in relation at least to certain of the disputes that arise under its general terms and conditions, and as regards how those disputes are being determined, it has Irish courts for the forum for certain issues arising, and Irish law as the choice of law of any issues arising from in relation to the general terms and conditions governing their contracts of carriage. So getting in at the ground level in that way is one way of allowing policies to filter up into how the law then might develop, and the opportunities for the law to be adjudicated upon and interpreted by Irish judges as informed by Irish lawyers. So the last point that I want to make is then what might happen next. I suppose there are a couple of things strike me here. One is that there could continue to be support for the type of practical approaches that I've just outlined as regards keeping things at home or keeping things local by inserting these kind of clauses into agreements. I mean, the bottom line is courts are there to sort out agreements. There are always going to be arrangements and issues that arise in relation to purely domestic disputes, but there are other ways of public policy moves, provided that there is support for it, to influence how disputes involving private parties and cross-border disputes could be determined by the Irish courts in particular, where that is something that can be perhaps systematically approached. And this goes for all sorts of, for all kinds of subject matter. If you think about the potential, there has been an increase before the Irish courts. I think we see recently of intellectual property disputes, of including patent disputes, which often involve companies which might be based here, but the interests are run much wider than that, and the potential for those kind of issues to continue to be developed here, with input from the Irish common law, but then feeding back into the broader EU framework is really very significant, and particularly when we see the UK fading away as a forum for those kind of disputes, but also as an actor having an influence in how the policies behind the codification of the legislation, which then informs how the regulation of those kinds of issues in relation to, say, for example, marketing authorizations or patent certificates would be regulated at EU level. So there's a very definite opportunity there. And my last point is just going to be this, which is that there's also a role, I believe, for the Irish courts to continue to play, not only where they're seized of jurisdiction because of a choice of law clause, but also in relation to the role for the Irish courts vis-a-vis the European Union Court, because an increase in litigation, an increase in interventions by Ireland before the European Union Court, and possibly even questions that are being referred to the European Union Court can raise the profile of the Irish judiciary and Irish lawyers, something that there was certainly a comment whenever the common law judges joined the European Union Court. The Italian judge wrote that the joinder of the insular judges had significantly contributed to the quality of hearings. Another aspect of the common law, the oral tradition, was very important. The questioning of those judges, and in turn the contributions that the lawyers played before the court were seen as very beneficial. So there is a crystal ball gazing exercise, I think, to be done there as to what might happen in the future. And the last point is that, of course, that requires support from our public institutions. We have a very strong Office of the Attorney General at the moment, which is very much getting and continuing to be involved. And the interesting thing is going to be in relation to another aspect of the dispute settlement, of remote hearings, because it does allow a participation in the adjudication of disputes in the EU in a way that one might have never even considered would be possible only 6 months ago. But that's another way that contributions can continue to be made, and the engagement that is absolutely necessary can be maintained. So thank you very much, Danny. I'm sorry I overspoke for a few minutes there, and I'm very happy to hand back to you now. Thank you.
Thank you very much, Margaret. That was great. And you stay with us for the Q&A as well, please, if you can. Thank you. Michael, I'll call you up next. Senator Michael McDowell, known to everybody. Career as a TD over 20 years, but formerly Attorney General as well, the turn of the millennium. And obviously, Michael brings a lot of experience to the topic. So you're very welcome, Michael.
Thanks, Danny. Thank you to the Society for the honour of inviting me to participate in this matter. And also thanks to the two previous speakers for bringing very different perspectives to the topic for this evening's discussion, and very, very, very clear views expressed by them. Just listening to Paul Gallagher, he was talking about the importance of statistics, obviously bearing in mind the name of the society, and he was impressing upon us the importance of scientific fact and how statistics plays a role in assessing what is scientific fact in many respects. And the real issue that I think that the crisis that he's describing is that people were talking absolutely enthusiastically 10 or 15 years ago about the information society. But now we have come face to face with the monster, the misinformation society, and how that is affecting politics, public opinion, public faith in democracy, public faith even in the rule of law. Now, it seemed to me, I recently saw an article in the Sunday Times where Mr. Justice Peter Charlton was quoted as saying that a judge doesn't decide the law, and the judge doesn't decide the case, the law decides the case. And that could be true, but there's a question mark over it, because it does raise the question, what is the adjudicative process itself? And it occurs to me that when the society was established in the 1840s, the English and Irish system of law was quite different from what it is now. Yes, it was based on precedent, and yes, it was described as a common law system. But in many respects, it was a shambles of a system whereby different systems of law and different jurisdictions, chancery law, common law, all competing with each other as internal jurisdictions in the English system, which were applied in Ireland as well. But in the 1870s, when the last major discussion of jurisprudence took place in the society, according to your introduction, there was a raft of legal reforms in the forms of the Judicature Acts, which actually amalgamated a lot of the fragmented legal systems operating both in England and Ireland. And we're talking here, and Margaret was very strong on this issue of the potential of the common law, the potential of common law in Ireland to influence Europe, perhaps the potential of common law in Ireland to generate economic activity and to encourage people to have resort to Irish law, firstly, or Irish courts, secondly, to resolve their disputes. And I make a few points about the common law system. I think its defining characteristic is not so much whether the law is codified. I mean, there are codifying statutes in common law countries. The defining characteristic, in my view, about common law is the process involved. And the central aspect of the process involved in a common law court is adversarial trial of issues. And some people sort of think this is slightly primitive. I mean, there was a time in the 12th and 13th centuries when there was such a thing as trial by combat of disputes between people. And there's a simplistic view that somehow the adversarial tradition in common law is a primitive hangover from some previous system, and that the modern scientific Napoleonic view is to have, instead of an adversarial system, to have a system inquisitorial determination of matters, that a judge effectively takes over the management of a case, a judge takes over the process of deciding it, and the oral tradition to which Margaret referred, of oral argument, is discarded largely, and it becomes an investigation, a judicial investigation of the facts, and a judicial investigation of what the applicable law is. Now, I think economically, I agree with Margaret. I think that economically, it is hugely important for Ireland that we do have the rule of law here established along the lines that it is. And that's not just a conservative position on my part. I'm saying that, a Japanese businessman, an Australian businessman, a South American businessman, a South African businessman, an American businessman or woman coming to Ireland and wondering how a dispute is going to be resolved in the Irish courts has an instinctive grasp of our system based on adversarial law. They know there will be a hearing, and our constitution requires that the hearing be in public, so that they know that the process will be public. It's not just a matter of sending in a few documents and getting an ATM type judgment from some process that you don't actually see how it works. The whole process is predicated on there being a dispute, allowing both parties to the dispute to articulate their case, to make their points to the judge, to contradict each other or invite the court to draw different inferences. And the judge in our system is an arbiter between two conflicting views, not just somebody who is coming with an idealized view of justice and imposing it on parties. He is arbiter between the correctness of one side or the other side in litigation. And that brings me to this idea of arbitral justice. Ireland and the United States and Canada now, and most of the common law world has a system of appointing judges, which, by the way, is obviously topical these days, which it brings people to the function of deciding cases from outside of the state's legal system completely, so that you become a judge and you're expected to be independent. And in Ireland, for instance, a High Court judge can decide that, having heard a case, that that a law enacted by the legislature is unconstitutional, or that an act of the executive, a whole policy, a whole regulation, a practice of the executive is unconstitutional and can annul the unlawful, the actions or the legislation which is deemed to be unconstitutional. That's hugely important because it differentiates us slightly from the United Kingdom, where Parliament is sovereign. And although there has been a dramatic change and evolution in United Kingdom law, and we now have a Supreme Court in the United Kingdom which does have a very strong arbitral role, as between Boris Johnson, for instance, and people who contested his decision to prorogue Parliament, things like that. In the end, Parliament in the British system is sovereign, whereas in Ireland, the sovereign is the people expressing themselves through the Constitution. But to me, one of the things that we should consider, and I admire Margaret's optimism on this point, but I'm slightly more skeptical about it, is whether or not the Court of Justice of the European Union is in fact a model which we should admire. And my own experience of it, and it's limited, I have to say, I've only been there twice in a role as an advocate, but my own experience of the CJEU, the Court of Justice of the European Union, is not unalloyed pleasure. And the reason is this, that you bring your case to the Court of Justice, you put it in writing. An advocate general expresses an opinion to the court as part of the system. You have a hearing, and the hearing is utterly different from anything that we would have in our courts. The judges that you appear before rarely ask you any questions. Now, this is at the top tier of the European legal process, and you're given 5 minutes to comment on the case, and the decision is then handed down. And the decision in the European Court, the Court of Justice of the European Union, is a single decision, and there is no indication of any minority dissent. So if there are 12 or 15 judges hearing the case, nobody has any idea, was it decided 8-7 or 15-0 or whatever. Nobody has any impression as to how the decision was made. Now, that isn't a very satisfactory situation, because it tends to leave the court in a situation that its judgment doesn't actually analyze why the defendant or the losing side lost, and why the arguments of the losing side were wrong. It tends to be much more, this is how we're deciding the case, and we are applying these precedents to arrive at that result. And curiously, if you go down the road from Luxembourg to Strasbourg, the European Court of Human Rights, which was established in the 1950s, largely inspired by United Kingdom law, does permit minority opinions to be expressed. And I think that the capacity to see that there were at least 6 people, say, in a 15-person court who agreed with the defendant is an important builder of confidence in the judicial process. At least the 6 say why they thought the loser should have won, and the majority have to, in effect, defend themselves against the minority opinion and show why the minority in the majority's opinion is wrong. And that's a hugely important aspect of adversarial procedure, which is, I think, missing in some respects from European jurisprudence. Now, another point that's hugely important about our system is that the Constitution requires justice to be administered in public. So it isn't a question of a judge receiving 2 sets of papers and going off into a room and deciding that the case. The actual process itself is subject to the public gaze. And the questions that a judge puts to either party and the theses which are advanced by either party are there to be seen by everyone. The media, other lawyers, whoever is interested in being in court, or people who have similar disputes and who want to see precisely how this dispute would be decided. So, for instance, a test case about the FBD's business interruption case, insurance clause. There is a test case going on, or I think judgment may have been reserved on it in the Irish courts recently. But at least everybody saw the argument, and subscribers to the currency will have seen an analysis of what was actually happening in court, who was saying what arguments appeared to have force or whatever. That process is absent if you don't have publicly administered law and adversarial law. Can I go to a second point, and that is that in terms of international capital, confidence in the rule of law is hugely important. And what I think is hugely important from Ireland from an economic point of view is that the quality of our legal decisions is maintained at a very high level. In other words, that our judiciary are people who are not merely people of sound judgment, but people who are able to articulate why it is that they're deciding cases. So that the advantage, for instance, of an American corporation coming to Ireland is that they know that, roughly speaking, and there are differences between American procedures and Irish procedures, and in some respects, but fundamentally, an American corporation who's a party to a proceeding in an Irish court actually can understand the whole system well and can see precisely why they are either winning or losing the case, and they have, of course, the right to appeal if there's an error of law which they can identify. Our system of law, and this is a point that I think Margaret has emphasised, that it's desirable that Ireland should be the place where cases are decided. And I share her view as an Irish lawyer, but that's obviously something which is good for lawyers. But our system of justice also requires that the state resources the legal system adequately to carry out sophisticated litigation and to give speedy results. And on that point, I think, wearing your IBEC hat, Mr. President, one of the problems that I think that people are concerned about is that law is becoming more complex and more costly, and people feel that going to law, going to an adversarial court is economically difficult to bear in many cases. And just over my lifetime as a barrister, which started in the mid-1970s, which just seems a long time ago now, all I can say is that there has been a dramatic change in the extent to which the determination of cases has become more complex. When I started as a barrister in the 1970s, the discovery process in Ireland was minimal, and it was only resorted to a tiny minority of cases. Now it's become generalized, and the obligation to make discovery has become almost an industry in itself. There are young barristers who, when they're not getting briefs to appear in court cases themselves, become discovery counsel, and they spend many happy hours or unhappy hours, as the case may be, assisting a party to make discovery of its documentation. That's making the law more complex. Secondly, in the 1970s and 80s, the use of written submissions to an Irish court was very, very small, whereas now in virtually every case that happens, there are written submissions demanded by the court, and the consequence of that is that it should be, at any rate, that the oral argument and the length of a case is reduced, because the judge can say, I understand what your case is in writing. Now let's test it out a bit in court, rather than have people elaborate all the law, all the previous case law, all the facts that they're alleging, and all the rest of it by oral testimony. So I think that in some senses, Irish law is beginning to converge with American law in the proliferation of the use of discovery and the use of written briefs. A brief in Ireland and in England is a document given by a solicitor to a barrister. In America, you file a brief with the court, which sets out all the substance of your case. And I don't know how many people here ever gone to the American Supreme Court. I did it when I was Minister for Justice, and it's a challenging place, because when you're called upon to speak in the American Supreme Court, you may get 10 or 15 minutes, and there is a traffic light system in front of you, and it's green, and then it goes to orange, and you're approaching the end of your submission. And when it goes red, that's it. You sit down, and that's the case over. And in America, for instance, the Supreme Court justices have what they call clerks, who do a massive amount of research and negotiation among themselves to sort of give their particular justice a view of the law in accordance with the judge's particular philosophy and approach to legal cases. So going back to what Mr. Justice Tarleton said, that it's the law that decides a case rather than the judge. I mean, you only have to look at the row about Ruth Bader Ginsburg being replaced by Justice Comey Barrett to understand that there's that theory that the law decides everything only goes so far. The identity of a lawyer is hugely important. And can I also throw out for your consideration in the context of jurisprudence the importance of appointing people to the courts who are genuinely independent. The notion that a judge or a number of judges in a collegiate court would not be independent is massively subversive of confidence in a legal system. And you have the Polish controversy at the moment, and you have controversies here now in our own country centering around the same thing. I just wanted to make a few points. Perhaps they're topical at the moment. One of them is this: that in appointing a judge, the primary characteristic is to choose somebody who is intelligent and independent, and will act as an independent arbiter between the organs of state that appoint him and the citizen in conflict with that state. That's of crucial importance. So we don't have a specialist constitutional court like many European courts have. The Germans have one in Karlsruhe, the French have a constitutional court separate from their ordinary court system. Our full and original jurisdiction given to Irish High Court judges is to determine all issues, including the constitutionality of acts of the legislature and the executive. And it's in that context that the characteristic of an appointee to the bench as independent, as not merely competent, but also independent, is hugely important. And the idea, for instance, if you were a United States corporation coming to Ireland, the idea lurking in the back of your mind that the person deciding the case might be wearing the green jersey, or if you were having a row with the Irish state, if you were an airline, say, that the judge would be biased against you in any way, or lean against you, or disposed to lean against you, is crucial to the question of whether you invest in Ireland and whether you are happy to adopt Irish law, and to submit your commercial interests to adjudication by the Irish system. So, going to the consequence of Brexit, and I'll finish on this point if I may. Going to the consequences of Brexit, as Margaret has said, we are now effectively the only common law country left in the European Union. It's a challenge in some respects because under our system of incorporating European law into our constitution, we did something that not even the Germans have done, and that is we acknowledged that European law trumped our constitution. The court in Karlsruhe has never said that the German constitution is completely subordinate to the European Court of Justice in Luxembourg, and there's been some controversy and tension between the two. But we do now face a very challenging time as the only common law country left in Europe. It is, as Margaret sees it, and I admire her optimism, a potential cause for hope that Ireland will become more important in Europe, in the development of European law. That's true. But put another way, the departure of Britain reduces the numerical strength and jurisprudential strength of common law fairly dramatically. And whatever happens in the next few weeks, as between Michel Barnier and Lord Frost, or whatever is decided, and I'm very optimistic that there will be a deal, and that a lot of poker playing and shape throwing is going on within the United Kingdom for the reasons that Paul Gallagher mentioned. Whatever happens, Ireland misses Britain very, very seriously in Europe. British analysis of proposed European legislation, British thought processes as to the appropriateness or inappropriateness at the Council of Ministers level, where I served as on the Justice and Home Affairs Council, which was particularly to do with law for 5 years. British values, whereas they weren't always identical with Irish values, largely coincided, and so did their interests with Ireland. So I hope with my hand on my heart that Margaret's optimism is correct. But I say that European jurisprudence, I think, will be weakened rather than strengthened by the departure of the United Kingdom. And Ireland, Ireland will be lucky to preserve the most valuable parts of our own jurisprudence and constitutional order in the face of pressure from the civil law states. So I'll leave it at that.
Thanks very much, Michael. And so, conscious of time as well, I might give it about 15 minutes before bringing to a conclusion. If you want to ask a question, you can use the Q&A or put up your hand. And I see Sean Barrett has his hand up. So Sean, I'll bring you in now, and I'll try and capture everybody at once to allow Margaret and Michael to sum up at the end. So Sean, do you want to come on? Camera there or sound?
I was on camera earlier.
All right, far away, Sean.
Can people hear me?
We can hear you perfectly.
Very good. Well, I want to thank our speakers, of course, Chairman. and for their presentations. In getting material together for this evening, I looked up the impact ratings of the Journal of Law and Economics, 0.290 compared to 4.281 than Econometrica. I don't believe that Econometrics has 15 times more importance than the law in relation to economics. And to the committee for arranging this session. When economists and lawyers get together, you can have very beneficial results. And I think of Des O'Malley as solicitor and minister, Peter Sutherland, barrister and commissioner, and the economists at the time, who reduced the average airfare in and out of this country to €52 compared to fares of over £500 and so on. That was important. They followed the example of Ted Kennedy, senator and law graduate of the University of Virginia, and Fred Kahn from economics as well. And distinguished members of the judiciary have made those economic contributions. I think of Roderick Murphy and Paul Carney in relation to taxis, and Mr. Justice Brian McMahon in relation to buses. There's work of 3 Nobel laureates recently, which I think deal with this interface, which our speakers have spoken about. George Stigler, 1982, on regulatory capture, which is a feature of the Irish system. Paul Krugman on moral hazard, 2008 winner, and James Buchanan on the economics of bureaucracy. And the common theme is that there are defects in property rights which reduce economic welfare when agencies are captured, when economic agents are exempted from the consequences of their conduct, and bureaucracies maximize inputs without reference to outputs. And a striking case reported on by the Controller Auditor General recently is that 98.6% of the 140 million cost of power rise in buildings has been paid by the taxpayer, only 1.4 by the people who built the buildings. I've always felt the Ministers and Secretaries Act 1924, by exempting officials in government departments from the consequences of their actions and attributing it all to the minister, is a charter for moral hazard. And Article 3 of the Constitution states the Controller Auditor General should control all disbursements and audit all accounts of public money. And I'd like to see that implemented. In relation to the proposals for the development of law here, I think there is some evidence from the EU and from the National Competitiveness Council that we have an expensive law system in Ireland. The EU Justice Scoreboard puts Ireland in the top 4 of court costs at 26.2% of claims versus 21.2% average. And the National Competitive Council says a transaction that would cost you 18.8% of claims here would be as low as 5% and 6% in Germany. Conveyancing at 1.5% of a house price does cause house price inflation, one of the themes of the present chairman. Now, the Chief Justice, speaking at TCD before the lockdown, did say that our adversarial system does reduce costs because the adversaries have to pay. But I mean, there is room for debate as whether our system is competitive in law or not. One of the features of law that commend themselves to the economist from the experience that I've encountered in cases, I think the features are adherence to fair procedures, audi alteram partem, Michael has referred to some of those, the right to be heard and in public and to be represented, the separation of advocacy from adjudication and discovery rights, and the right of appeal to a higher body. Those features don't apply in the systems that our 3 Nobel laureates spoke about with regulatory capture, moral hazard, economics of bureaucracy. We could learn a lot from applying those legal principles to the way in which much resource allocation takes place in our society. Finally, going back, Chairman, to the 15-to-1 impact ratio from econometricians over lawyers, I think we'll all agree we came to the right meeting this evening. That 15-to-1 is an entirely bogus figure. We've heard a lot from our 3 visitors. And I hope that the development of contacts between law and economics stimulated by this meeting will continue, because I'm inspired by what I've heard and not at all impressed at this stage by the 15-to-1 ratio in favor of econometricians against lawyers. Thank you.
Thanks very much, Sean. Donal Brolacon there, do you want to come in as well? You've made some comments. You might like to articulate them yourself before I hand over? Donal, can you?
He's coming in now.
Come in. Okay.
Apologies, he may just have been promoted to on the Zoom system. He may not actually want to come in. I don't know, Donald, if you're, oh yeah, you're unmuted now. We also have Owen Flaherty, I think, made a question as well, perhaps more recently.
Yeah, Owen, please come in. Donal, we'll take you after Owen if Owen wants to come in.
This is one of the occasions where you lose the benefits of face-to-face meeting up. There's Owen there.
Sorry, yeah, sorry, I just changed the setting on my computer, so I missed whatever you just said. Yeah, basically my question is to the speakers is really what can we learn from other EU countries as regards their systems? So I suppose a lot of the message behind this was that the Irish system is very good, and it's a shame that other countries don't have it. What can we learn from them? And secondly, I suppose echoing the point made earlier, can we learn from them in relation to high legal costs and potentially longer than average court case times? Thank you.
Thanks, Owen. And Donal, I think you're on there now if you want to speak.
If Donald's not, I might add a question as well, if that's okay.
Please do, and then we'll.
Using my, I don't even have to wait to get permission to get promoted. One of the things that has come up, so my area is a lot of it is dominated by housing, and obviously over the last 10 years there's an issue around housing supply, and one of the frustrations, and it's not just an Irish one, but I think Ireland suffers from it when you see things like the data center that Apple built in Denmark versus the one that never got built in Ireland, is the ability of the legal system to become sort of a quasi-planning system. And is there any way, I know with the common law, the nature of it is that there's not always another option, but there's quite a lot of extra options compared to systems like maybe Denmark, where it's there's a certain number of ways for recourse, and then after that, the decision is made. The Irish system seems to be the opposite. Is that a function of the law? Am I picking on the wrong villain, or are there ways that we can reform it to make the legal system contribute to the delivery of housing?
The last one then, John Flanagan actually has asked a question, and I definitely will hand over. John, do you want to come on? Unmute yourself there, John. You've got permission anyhow if you want.
Hi, yeah, just a general question. Thanks very much to all the speakers for a very interesting trio of discussions. I just mentioned, just based on points that all three of the panelists have raised, I wondered how judges manage to keep abreast of modern statistical topics, cutting edge technologies. Michael mentioned that international business people may choose to have their cases heard in Ireland. So how can a judge be expected to, or how does a judge maintain and develop the requisite understanding of these technological concepts in order to ensure that a fair trial is heard? So the example that I've given is, say, an American company wishes to challenge a UK company over use of a statistical algorithm that the US company claims is theirs, and the UK company thinks otherwise. So yeah, that's my question. How are judges expected to keep abreast, to be so statistically literate that they could fairly hear that case?
Great, thanks very much, John. So listen, I'll hand back to Margaret in the first instance, and then to Michael to finish up. So appreciate the questions, and Ronan will follow up for the journal purposes. Please do, because it's nice to get that contemporary viewpoints from the participants as well as the panelists. So Margaret, over to you.
Okay, thanks very much. And just to say again, thank you for the invitation. And it really does feel like a proper meeting of a society with the discussion, which is of course very welcome, because as you all know, when you're doing these piece to cameras, it's like speaking into a bit of a void, and you don't get the same sense of camaraderie and collaboration as you might normally. So this is very much to be appreciated from my point of view as well as a speaker. So I think that in fact that the other question as well from Donal was looking a bit at costs, as far as I remember. So first of all, dealing with the issue that was raised by Owen in relation to costs and what we might learn from other the other systems, legal systems still within the EU. I think it's a very fair point. It's also a point that was made by Sean very forcefully in relation to looking at the economic input of jurisprudence and the determination of disputes, because costs, just as they put manners on people when they're making regulatory decisions, because they're often informing those decisions when you're looking at, say, consumer impact or output, costs also inform players whenever they're in litigation, particularly because there are consequences to steps in disputes and cost awards. And it is fair comment that costs in the Irish system are high. One statistical way of looking at, if you want to go and look at some, back to the EU, but it is the closest point of comparison that we have here by way of looking at other legal systems. But one of the drivers for the special costs rules that were introduced in Irish law for environmental law disputes was because it was considered that there was disputes throughout the EU couldn't be brought because there were prohibitively high costs, and particularly Ireland and the UK were identified as legal systems where that was the case. Comparatively, there are other systems where it wasn't so significant. So it's true. Things like, as Michael said, the extensive discovery exercises that now take place often within trials contribute to that. Perhaps we could learn something from civil law systems where you don't have that interposition, although I have heard actually Judge Costello speaking not so long ago to the European Bar Association about how in certain cases that she had been involved in, there were significant documents that had come out of discovery. So there is a trade-off against the reduced costs compared to what potentially might come out of a procedure that does increase the costs and length of time in a case. So what can we learn from other civil law systems? Perhaps look to see how they do keep their costs down, if costs are a disincentive to having disputes adjudicated and rights determined. But then there is, as Michael said, the other weight to go in the balance, which is if you don't have the oral adversarial proceedings that is lacking, where a dispute can be settled more easily and on the papers, then there are drawbacks to that as regards rule of law issues and just a proper development of a reasoned jurisprudence in relation to particular areas. I think I'll leave it to Michael to perhaps identify some of the other bits of the civil law systems that we might benefit from, but perhaps I ought to just also say that I do agree that I think there is going to be a problem for Ireland trying to continue to promote the common law. And in fact, one of the reasons, or one of the flags that I was flying as regards us trying to get more involved in Luxembourg case law wasn't because I think it's brilliant at the moment, but that necessarily that we would like to be able to make a very positive contribution to how it develops in the future, including by participation at oral hearings by making a concerted and consistent contribution in that way. As regards planning and length of time, that was a question from Ronan. It may have something to do also with not only with the fact that there are, as Sean also was drawing attention to, the fact that administrative decision making borrows a lot of fair procedures. So you'll already, before in Bord Planola, you have a developed inquiry procedure, adjudication, determination, and then there is now potentially three levels of dispute, well, or possibly two, depending on the nature of the case, a High Court, possibly Court of Appeal and Supreme Court. These things do take time. They take less time than they used to, and court cases now can get on very quickly between the appellate levels. But I think that unless there is a wholesale change to the constitution, the legislation that allows that, I don't see how we're going to very quickly revert to a much more accelerated procedure. And then you do have knock-on effects, as you say, with the Apple situation being a very practical outworking of that. John's question about judges, keeping judges informed, I'll just make a couple of comments there. We do, in relation to the sort of dispute that along the lines of the type that you outlined, John, a hypothetical dispute like that, we have a specialist commercial list where there are judges who are impaneled, who are on that list, who hear very complex and technical disputes, including in relation to copyright, patents, other kinds of property rights and contractual commercial agreements. And the quality of the judgments in those areas, I think, is testament to the fact that if the judges aren't getting education formally, that they're informing themselves in a very significant way. Also, the nature of our system is that there is a high expectation that the legal teams will assist the judges, and that's something which comes from the adversarial nature of the proceedings rather than the inquisitorial procedures, and something actually which was highlighted by the Chief Justice in a case involving lawyers where a question had to be referred to the European Court of Justice to be determined. So the judges, I think, are testament to the fact that they're interested. There are, of course, other specialist bodies and associations. So, for example, and I see a number of names from the Hall of Fame in the regulatory sphere online: Paul Gorecki, Dennis Cagney, and they would speak very eloquently, no doubt, to the education that's given not just the regulators but also to judges in competition sphere. There are networks for the judiciary to participate in and be kept up to date on those sorts of issues. So I think we're certainly very far from the days where and never were where there were English court judges asking ridiculous questions, and hopefully we're closer to the Oliver Wendell Holmes, where the judiciary are closer to the determinations and machinations and interests of what he might have called the common man. Although, of course, and I ought to have said at the beginning that all of those masculine references in his citation should have included the common woman as well. So that those are my musings. I'm sure Paul, or sorry, I'm sure that Michael has some very erudite things to.
Thanks. Whoops.
Well, just briefly, I mean, I think there is a danger, to answer a number of points that have been raised. There is a danger that we are over legalizing and over litigating in Ireland. I mean, for instance, I saw recently, I've no knowledge of the merits of either party, but I saw a whole development of so many 100 houses just cancelled by a judicial decision. I think yesterday, a judge who I greatly admire, Judge Senan Allen, knocked on the head a whole sewage scheme for North Dublin on the basis that it failed to take adequate account of environmental considerations, and the process was flawed. Those kind of things, by the way, wouldn't have happened when in the 19th century or for most of the 20th century. We now have this area of administrative law where the judiciary are brought in as a kind of they have this function of questioning and supervising the methods by which administrative decisions are made. And you have to ask, is it in Ireland's interest, for instance, that there should be so much litigation in so many areas, and that Margaret there mentioned what I think is the Aarhus Convention, in which the European system said that liability to costs was having a damping effect on environmentalists' capacity to protect the environment, and that the economic risk of losing a case was too big. So the capacity to award costs against an unsuccessful litigant in an environmentally related case has been severely curtailed by the European courts. The real question is, and by the way, I think Margaret's practices in England as well as in Ireland, the English judiciary have become much more activist in terms of extending judicial review to areas and topics which, 30 years ago simply would not have had a chance of being litigated in the English system. So litigation is not like window cleaning. It's the more windows that are cleaned and the cheaper it happens, the better. That's the general proposition. But the more litigation that happens and the cheaper it is not necessarily. I'm not speaking now, by the way, in favor of expensive litigation, but I'm saying that it isn't like producing widgets or something like that. The more and the cheaper, the better. Litigation, there's always a losing party. And especially when the state is at the receiving end of litigation, there are always potential social costs. I mean, I was Minister for Justice for years, and the courts, and we set up a refugee legal service, and it was a state-sponsored legal aid scheme for people who wanted to claim refugee status and avoid deportation. And the whole system silted up and still remains quite problematic in terms of anybody who claimed asylum was refused it, being asked to leave the country. That system became largely inoperative due to the volume of litigation which existed there. To add to the question as to whether how we keep our judges up to par in relation to algorithms and things like that, our system does allow either side to produce expert testimony, and also allows the judge in a case to appoint an expert to advise the judge. So, I mean, you don't have to be a first-class honors mathematician who can understand the intricacies of algorithms to determine a case involving algorithms if both sides have an expert and you yourself can have an expert. Sean Barrett raised the whole question of, the immunity from suit, really, of administrators. And as Margaret says, I understand there are regulators watching this discussion this evening. In some respects, there should be curial deference by the courts to specialist regulatory tribunals. Sean mentioned, for instance, the taxis decision. But the interesting thing about the taxis decision was, I remember because I was Attorney General at the time, that the vested interest was the taxi industry in Dublin, which wanted to confine taxis to less than 2,000 for the city. The challenge that was brought to it was one which was determined in court. But the question that arose, and Robert Malloy was the minister at the time, would he appeal that decision? and he asked his Attorney General, who happens to be talking now, am I obliged to appeal that decision? And he was told, no, you're not obliged to. It seems to make eminent sense. Get on with it and deregulate the taxi industry. So, can I also confess to having been involved in the Apple case for the objectors, and just so that people should know what the basis of their claim was. It was that on board Canola, in choosing this location for the Apple data hub, had not taken into account at all that the plant would use between 5 and 7% of Ireland's electricity, in the context that that other departments of state were planning to reduce our dependence on electricity in the context of meeting our climate change obligations. But I suppose, my clients felt that on board Canola didn't take into account the energy requirements adequately in deciding whether or not permission should be given for that development. I think that the continental system would have been far less kind to my clients than that a specialist tribunal somewhere in Denmark, as did happen, would have dealt with objections, if there were any, to the twin plant in Denmark. And I finish on this point. I do think there is a danger in excessive judicial review, and I do think that there has to be judicial continence in exercising the power to veto or overturn decisions of tribunals, agencies, and the like. And I think my own view, and this is probably coloured by the fact that I did serve as a minister, I think that we are probably over generous to those who seek to challenge things in the court, rather than having them dealt with at a political level, where politicians, elected politicians, should take the blame. I don't agree with Sean Barrett that the administrative civil servants should be exposed to personal liability when they make a bags of things. But I do believe that ministers in particular should not hide behind the courts and judicial review. They should take the blame when they get something wrong.
Michael, thank you very much, and Margaret, and in absentia, Paul as well. I think it's been fascinating. Agree with Sean, the quality of the inputs, and as a society, we shouldn't leave it as long to bring back jurisprudence. Ronan, anything from you just as we end?
The only thing is that I'll be following up with the various contributors after the main contributions to make sure that their comments have an opportunity to be reflected in the journal. If you do want to get ahead of me on that, you can send them through to secretary@sisi.ie. Otherwise, I'll pop you an email in the next couple of days and we'll take it from there. And likewise, the formal contributors, I'll be in touch with you in due course about your submissions as well.
And I think the next is in the new year, so I wish people...
That's right. I'll send out a save the date, but our next session is going to be the Barrington lecture. Actually, let me get the date now, because it is set in stone already. Well, not stone, yes. But...
So while you're doing that, Ronan, just say again, thanks everybody for coming on. And if you have the date.
It's the 21st of January. We have our Barrington lecture. So we'll put an announcement up on Irish Economy next week about that. Very
good. And just as an aside, when the previous Barrington medalist is the CEO of Qantas, much in the news this week, Alan Joyce, just to connect up. Aviation was mentioned quite a lot in passing. So listen, thanks everybody. Again, thanks to our panelists, and a great evening. Okay, thanks everybody.
Thanks very much.
Bye.
Thank you.